Muskan, the moderator for today's session organized by Law Internships. Law Internship is started with the objective of providing first-hand experience of day-to-day functioning of various legal bodies through legal internship to the students pursuing undergraduate or postgraduate programs in law by Mr. Shubham Solanki sir, co-founder and partner, and Ms. Amrita Jain ma'am, partner at Law Internships. We have amongst us Mr. Saunak Rajguru sir, attorney at J.Sagar Associates, New Delhi. Sir is a Bar Council of India Trust Scholar and has won Bar Council of India Moot Court competition and best advocate in various other moot court competitions. And not only that, Sir has also won various positions at trial advocacy competition, negotiation competition, mediation competition, etc. Sir has also been invited as the moot court advisor in various occasions for national as well as international moots. We welcome you, sir.
Hi, thank you so much, Muskan. Yeah.
Brief topics to be covered in today's session are basics of mooting, understanding and interpreting factual metrics of a proposition, research technique, taking an ideal memorial, jurisdictional issues, tips for an ideal speech, compendium basics, various other technical and substantive details concerning moot. Before we begin with the session, I would like to give you instructions. It's going to be an interactive session. In case of any question, either write in your chat box or unmute yourself and ask your question. I also request everybody to mute their mics and turn on their videos. Without delaying any further, let's begin the session for today. Over to you, sir.
Thank you so much, Muskan, and thank you for everyone who managed to make out this particular session today. I understand we are in a Sunday, and I hope I won't be taking much of your time, but I'll quickly brief you all as to how exactly one should approach towards a moot court competition. But before that, if someone can just confirm that my voice as well as my picture quality is quite clear and everyone is able to hear me properly. If I can get that confirmation, I'll immediately proceed.
Yes, sir, you're audible and visible too.
Perfect, thanks. So, first of all, I will be covering a few aspects regarding ABC of mooting today. Obviously, in a 1 hour time, we can't go into, the very specifics and details of each and every aspect, but I'll try my best to cover in entirety what it takes to even start mooting and how exactly one should proceed about the moot court competitions and how one should culminate the whole exercise of practicing for the moot into a final moot court win, right? And that should be our endeavor today, and that is what we'll exactly achieve in this 1 hour. So to give you a short brief of what I'm going to cover today, I will first of all discuss as to the pre-preliminary stage, which I ideally call it what should ideally someone should do even when the proposition or the fact sheet is not released. What should be the kind of approach followed by the students at that stage? Then I'll slowly talk about the proposition release and post proposition release stage, where we'll discuss a lot of aspects as to how one should approach towards interpreting the fact sheet, how one should adduce the issues from the facts, how one should frame the arguments, what should be the ideal way to go ahead with your legal research, and what should be the steps envisaged in your legal research, and ideally how exactly you then need to proceed about your memorial. We'll discuss about the memorial specifics, which is nothing but a written submissions that summarizes your arguments, right? Then we'll be covering a lot of aspects concerning the oral advocacy part also, right? How exactly one should proceed towards the oral advocacy rounds, how should you prepare your speech, how to keep the bench engaged, what mannerisms to be followed in the moot court round. So all of that will be covered today. If you think that, under the broader aspects that I just mentioned, if you think that there is something missing, then please feel free to leave a suggestion in the chat box. I'll definitely try and cover that aspect also. But this was only a preliminary and broader perspective of what I'm going to cover today. This is, and I'll be explaining that in detail. So if you think that if there is anything missing from here, then please suggest that, and I'll definitely, take it up. Also, I request all of you to be on mute if you are not going to speak, but you can definitely unmute yourself if you have a question. I love to answer all the questions. I want the session to be interactive, and therefore, please feel free to ask me any questions. Interject me at any point of time. You can leave your questions in the chat box also, and I'll request Muskan to take up the questions and let me know, and I'll answer it then and there. The idea is not to leave all the questions towards the fag end of the session. If you think that there is something pertinent that you want to ask, maybe something that I'm dealing with, and you are confused about it, or you are having a question, maybe out of your own experience in any moot court, then please feel free to ask that question, right? So that is how we are going to proceed about this session. So without any further delay, let me just start with the very, very basic aspects concerning any moot court competition. Okay, I think many of you may be in the initial years of your college, maybe the second year and the third year. I'm assuming there are no first years because of the fact that hardly any first year have joined in this particular batch. So therefore, if you are in your second and third year, and if you are figuring out what mooting is all about, the first 5 or 10 minutes will be specifically for you, and then I'll slowly go into advanced levels, right? So to start with, mooting is all about a demo moot or demo court proceeding, where ideally a proposition is given, where the students are expected to play the role of a lawyer, and you are expected to argue from both the sides. That means you need to argue from the side of the plaintiff or a petitioner or an appellant, and on the other side of a respondent or a defendant, and bring out a case holistically from both ends, so that in different rounds you will be playing the job of a different lawyer, and therefore you have to take sides, and therefore you should be ready with your case to present from both the sides in different rounds. And that is what it undertakes in your preparation stage, where you have to prepare maybe sometimes for 2 3 months, sometimes for 6 7 months, and I have seen people even preparing for a single moot for over a year. If it's an international law moot, sometimes the national rounds take about 6 7 months to conclude, and sometimes the international rounds are then scheduled after a gap of like 5 6 months. That means one good year of your whole law school will be devoted towards preparation of a very, very good moot. In that situation, what should be your ideal approach, how you should effectively use your time, whether all the time should be given to one single moot, or if you have such huge gaps in your moot rounds, then should you also be pursuing other moot court and other activities as such, right? So something of that sort can definitely be discussed today. But before that, let me just focus only on the approach towards domestic moods today, because we have finalized that we'll be discussing a lot about domestic moods, because that is ideally what someone starts mooting. They start with a domestic mood, and therefore I thought that let's fix a session on domestic moods, and let's address the key issues governing such moods, right? So to start with, the first and foremost thing that one should do is prepare and finalize the correct team. It's very, very essential to know your team. It's very, very essential to have a formidable team, someone who you can trust, someone who is reliable, someone whom you are comforted with, and it may not necessarily be your friends, right? Please understand that mooting is a professional journey. You cannot just anticipate that, okay, he or she is a great friend of mine, and I'll team up together, and that will be a great kind of an preparation stage, will be comfortable, etc. No, that doesn't happen that way. I'm not saying that friends won't make good teammates. All I'm trying to say is, if you can ensure that there can be a professional relationship in the team, I think that is how one should approach towards forming a correct team. Now, please make sure that you have a good combination of speakers and researchers. You don't want three speakers and ultimately one being unhappy or disheartened of not qualifying as a speaker, and ultimately going as a researcher. That brings the morale down of the team, and that should not be the approach. Therefore, the ideal approach is bring harmony to your team, have a good composition of your team structure, make sure you have two speakers who are very good in the approach, not on the basis of how they speak, but what you should look at while preparing the team is how rational is someone in his approach, how logical is someone in his arguments, and how calm is someone in dealing with the situation. These are, I think, the three main attributes if you're looking at any speaker or in your team, right? Therefore, have someone who has the ability to analyze things well, rationalize things well, and put forth submissions which are backed by logic instead of merely being technical and citing case law after another. Please understand that unless you quote a case law and unless you relate it to the facts of the present case, no judge will ever accept your argument because of the simple fact that it's a settled position of law that a case law or reliance on a previous judgment will have precedential value only if the facts are similar or at least identical. In that situation, what you need to do is you need to have your own rational analysis and connect the case law that you want to rely on with the facts of your case. And you need someone with a rational mind to do that. Someone who is just technical and cites ABC cases and comes back without correlating it to the facts of the case will fail as a speaker. But someone who may not be a great speaker, may not be someone who is very good with English. The language is not important here when it comes to Moot. What is important is how far you have researched, how well you can connect to your case, and what efforts are you making to make your client win. That is what it takes to be in a moot court. And therefore, please make sure that when you choose your team, you keep these things in mind. Because I feel that you can be, a great speaker, but if you cannot be a good mooter, if you are not, having these qualities. Therefore, analytical skill, rational skill, making sense out of something, and finally it's very very important to be calm and patient because judges will be posting flurry of questions and you quickly throughout the rounds. Therefore, you can't have a short tempered person in the team. Even if someone is short tempered, you need to ensure that you make him practice so much that at least so far as the purposes of the moot court rounds are concerned, he or she does not reflect the short tempered character or behavior. Right? That's very, very important because you can't be in a situation where a judge is asking you a question and you are changing your facial expression maybe to express your displeasure, or maybe you are getting aggressive because of the number of questions thrown at you. So those are the situations which are to be avoided because at the end of the day, the lawyers are to assist the bench, and whatever questions are posed by the bench is the lawyer's duty to assist them effectively. Therefore, please ensure that these are the few preliminary steps that you need to keep in mind when you choose your team. Because I think that's the foundation. If you don't have a good team, you can't win a moot. If you don't have a good team, you will maybe possibly get yourself out of the team and even ultimately don't go for the moot at all. I've seen that with number of teams leaving the moots midway because of this factor. Please ensure this does not become detriment, number one, for you, and also number two for the college, because it's ultimately the college's reputation and the stake will be questioned. And therefore, please ensure that you have a very very good team. A balanced approach should be followed, and keep whatever I just said in my in your mind, when you go for your next move team. Once the team is finalized, the next thing, obvious thing that you need to do is choose the correct moot. Now, while choosing the moot, please don't go by the name of the college. Please understand that mooting is all about understanding the law and not what college you are going. Maybe going to a fancy NLU won't help, but maybe some small town law college organizing a moot in the area of law where you are interested in, where you find your comfort level. Okay, and that may be helpful for you because you are learning something. Doing a fancy moot in a fancy law college doesn't help much because that doesn't contribute towards your development. Maybe if you think that your CV will look great if you do a moot in maybe a top NLU versus some government college in Pondicherry, I think you are mistaken there. Maybe if you can demonstrate well that why you did that moot in a small college in Pondicherry. Yeah, sorry, is there a question? Okay, yeah. So yeah, I think there's some echo here. I can hear my own voice back. Okay, it's fine now. Yeah. So therefore, choose the correct moot, and what should primarily go into your mind while choosing the moot is twofold. One is whether you're comfortable with the field of law that the moot governs with. Second is whether that field of law will at least help you somewhat in preparing, or rather in furtherance of your career motives and goals. So for example, it's no point doing a constitutional law moot if you're ultimately going into the corporate sector. Secondly, it's no point in doing similarly an intellectual property law moot if you are interested, in fact, in competition law, right? Therefore, please choose your moots well based on your areas of interest. Make sure all the three or all the five members of your team also have the same intention and same area of interest, and that is how you can actually proceed about your moot court things, right? So I just tried to cover two aspects which are very, very crucial and which are often ignored by many. That is, number one, prepare a very, very good team and choose the right moot that you should participate in. Now let's come to the important aspects concerning moot courts, which will be a bit, subjective. But yeah, what we actually should do is keep these things in mind and take it forward. Now let's discuss about the pre-proposition stage. Now, once the team is ready and once the moot is finalized, you know that, okay, you're going to say XYZ moot. And you also know that XYZ moot is going to touch base on a constitutional law proposition. So if that clarity is there, what you should do next, even before the proposition is released, is read the basic materials concerning the subject, read the background of the law, read the root from where the law has evolved, because it's very important to understand the statutory intention and the intention with which a law was framed, just to analyze the consequential effect of the law. And therefore, whatever you want to interpret out of the provisions of a particular statute, it has to be in conformity with the intention of the statute itself. Therefore, if you are making an argument which goes contrary to the very scheme of the provision of the law, then your argument will be bound to fail, right? Therefore, understanding the law, the backdrop, the whole history behind formulating a law. I'll give you an example here. Okay, now for example, if say for example there is Electricity Act today, okay, it governs the whole regulation of the electricity domain in country, how electricity is used, how it's generated, how the consumer ultimately gets electricity to the houses, right? Now for example, initially the state government and the central government were the primary vested institutions who were regulating this whole process. But then there came a 2003 act, okay, which now has transferred all those statutory responsibilities on different judicial commissions. Now the all that I'm trying to say from this particular point of view is that the intention of the 2003 act was to distance the government from regulatory affairs, right? You need to prepare your arguments in such a way that you conform to that particular statutory intention, and that will guide you in preparing your submissions in the matter. Therefore, always read the preamble of any act that you are reading, read the statement of objects and reasons, also read the statutory backdrop, which is sometimes called as Travox preparatories in the international law sector. Same goes in, say, for example, the bills being laid down, the discussions in the parliament. For constitution, it's the constituent assembly debates that you should ideally look at. I think it's a holistic view that should be taken in before you actually channelize your mind and streamline it in the exact direction where your proposition wants you to take to, right? So that should be your step one, even before the proposition is released. Now, once the proposition, yeah,
So there is a query from Abhishek Bansal. It is
yes.
that how much is the concept of moot actually relatable to the practical implementation in the courts?
Okay. See, the aspect is what moot courts will help you is number one, it gives you the confidence to argue a matter before a real court panel. The reason is I have argued before sitting Supreme Court judges, I have argued before sitting High Court judges, especially in the final rounds and the semi-final rounds. And I've also argued before different lawyers practicing in the field who are there to grill you in and out, right? Therefore, if you participate more and more in moots, it at least builds in that confidence within yourself to tomorrow go and argue before a real court. Things will be different. The methodology followed in the moot court is totally different from how it works in a real court situation. However, all I can tell you is the amount of research, the analysis that you need to do for a moot court remains the very same for a real court situation. The research and analysis that goes into the preparation will be reflected there. Your ability to quickly get onto a particular proposition and go to the correct statement of fact or correct proposition of law will be enhanced for sure. That is how mooting will help you in the real life situation when you ultimately go for litigation. Even if you are going for a corporate research, a corporate based internship, or corporate job for that matter, when you are in law firms dealing in the corporate side, where maybe you are involved in a due diligence process, what happens is your ability to quickly find the law and get the research out of it will also be enhanced, because mooting is not just about oral advocacy. Mooting is also about preparing, researching, analyzing, and interpreting. Therefore, step 5 and 6, okay, I'll be covering as to how you need to research, how you need to analyze things, and how you need to interpret it to frame the issues and argue. So, argue is the last stage in a moot, and that is what will help you in litigation. But everything before that will also help you in the corporate side. So, I think mooting is some activity that gives the level playing field both to the litigational lawyers as well as the transactional lawyers, right? Therefore, I'm sure that if you pursue mooting as an art, as something, if you try your best to give everything at it, I think you will learn a great bit of it. And don't think that, if it's not 100% similar to a real life situation, I'm sure that it at least contributes in 60% towards that aspect, and that will definitely give you the first step, and you will be definitely seen in at par with your seniors in a law firm, or maybe in the real courts. Your briefings will be great for senior advocates, and I think all of that matters, and that confidence is definitely built in by moot courts. So coming back to it, okay, the proposition is very, very essential. What you need to do when you receive a proposition is, number one, read it 5 or 6 times before you conclude anything about the facts. Okay, give it a holistic reading, read it every time, break it fact by fact. And what exercise you need to do from the fact sheet is prepare a table. On the left, prepare the undisputed facts, and on the right, keep all disputed facts. Now, what happens with undisputed fact and disputed facts is, undisputed facts will be something that will not be re-agitated by someone as a lawyer. But disputed facts will take you to your issues at hand. I will give an example to explain this, but before that, let me just explain you what exactly disputed facts are and how they are helpful. So, disputed facts is obviously something that someone is going to argue or contradict or challenge in a court of law. In that situation, you need to ensure that you find the disputed facts well, and then channelize your entire research accordingly. Because please understand that disputed facts, if questioned, will therefore become your basis of your issues. I'll give you an example to explain this. Now, consider a situation where there is a husband and wife in a house. The watchman in the last night had seen the husband as the last person inside the house, and the next morning the wife was found dead. Now, the first question is, who has killed the wife in the intervening night, right? The first, question that can be as to whether it's the husband who has killed the wife, whether it's the watchman who has killed the wife, or whether there's a possibility of any third person entering the house and having killed the wife. Now, these are certain undisputed facts versus disputed facts. I'll clearly split it now. In this, undisputed facts is they were a husband and wife, unless obviously challenged by way of any such marriage certificate, etc., which is not necessary for your purpose. Second is the undisputed fact was there was a watchman, and the watchman has also seen the husband as the last person in the house. These are certain undisputed facts. But what is disputed is who has killed the wife. Any question that you want to frame that A has killed the wife will be a disputed question of fact, which needs to be proven by concrete evidence. Therefore, your whole research will govern around this disputed fact, and you will have to find the provisions of law, such as, say, alibi, or such as, say, the last seen theory doctrine, which simply says that, if someone was last seen with the victim, and he or she will be presumed to have committed the offense unless proven contrary. Therefore, the research will be governed by your disputed facts. The moment you identify one disputed fact, you will get your one line of action for your research so far as a question of law or a question of fact is concerned. Therefore, the approach from any moot court proposition is divide your proposition into two: disputed and undisputed facts. Then channelize your disputed facts. Say maybe you have 80 disputed facts, convert them into broader headings. Maybe you can have 20 disputed facts into one heading, and those headings or the broader heads will become your main questions of law and questions of facts, right? That is how you adduce your issues for your moot court competition. So whenever someone asks me a question, how do you bring out your issues if not given in your facts, I simply say that I identify the disputed facts, and my disputed facts eventually take me to my questions of law and question of facts, which are basically nothing but the issues at hand, right? Therefore, that is how you need to channelize it. Having said that, I do not by any chance undermine the undisputed facts and their importance. Please understand that undisputed facts will be something, which will help you connect the dots while making submissions, while arguments being made, and they will help you patch in, or they act like, the each stair between the first and the third stair. It's like the second step that you need to take. So therefore, please understand that it helps you connect the dots, and it relates to your arguments, and it can sometimes take the whole case in favor of you or against you. I'll give an example here again to make you understand what exactly an undisputed fact is. Now, for example, if there is a population figure, if there is any data measurement, any height of an individual, a height of a panel, for example, such as, if there was a chimney around, or if there is a boundary wall, which is of a height of say 17 feet. And the question, if I relate back to the same example, you can always argue that the boundary wall being 17 feet and there being no signs of someone trying by a way of a ladder or something to have climbed it, there is no possibility of someone just entering the house because it's a 17 feet wall, and the chances are reduced, right? So these are the kind of arguments you can make. But I'll give you one example that I personally had made in one of my final rounds in a criminal law proposition again. Okay, the question was whether chemical poison, okay, was enough to cause the death of an individual. In that case, it was a, I think, an undisputed fact. Yes, it was an undisputed fact that 50 milliliter of epinephrine, which is a chemical poison, was given to an individual, and the prosecutor was alleging that that was the cause of death. Now, I did some research. Okay, I did some good research in terms of understanding the medical jurisprudence behind the quantum or quantity of epinephrine that will be required to cause the death of an individual. I got some good medical based reports, of doctors or well acclaimed doctors testifying that 50 milliliter is not enough. It's only 250 milliliter as minimum that can cause the death of an individual. I based that report as my argument, and I easily pleaded that, see, it's an undisputed fact, and the prosecutor has accepted that 50 milliliter was the cause of death. However, the scientific evidence shows that 50 milliliter cannot cause the death of an individual. There's something more to it, and the prosecutor has failed to prove in anything in that regard, and hence there should be an acquittal on immediate basis, right? And immediately at that stage, even without waiting for the whole rounds to conclude, the judge immediately pointed out that, oh, that was a brilliant argument. The reason why this clicked was because the way I utilized an undisputed fact of just 50 milliliter. There was only a small figure mentioned in the fact sheet, turning the whole case in my favor by arguing this, right? So you never know when your undisputed facts will take you to your main, win, and maybe that will be your key, or maybe the guiding mantra, or maybe that one thing that will make you win around, right? So therefore, I just explained you the importance of undisputed facts and disputed facts. Just to summarize it in a crisp, disputed facts will help you take you to your issues, and undisputed facts will help you in connecting the dots throughout the rounds, right? Now, having dealt with the proposition stage, let's
Excuse me,
go into,
sir.
yeah.
So there is a question in the chat box from Sarvesh Singla, that is there any base case which is to be recognized while comprehending the moot proposition?
Sorry, can you please repeat that question? I lost your voice for a while. I think you're on mute, Muskan.
Sorry.
Yeah.
Is there any base case which is to be recognized while comprehending the moot proposition?
No, as in there is no base case as such. See, the proposition has to be dealt in a different perspective with an intention with which it must have been drafted. The best thing is maybe you can rely on the recent incidents, if any, regarding the subject area, and then maybe draw an inference to that. However, my suggestion is proposition has to be taken in its letter and spirit. Nothing can be assumed in a proposition. Therefore, I will advise just take the proposition the way it is. Do not relate it back to any base case or any example as such or any real life situation unless so provided in the proposition. Because ideally, the proposition will be restricted. It will clearly say that nothing may be presumed into this. Even if it's not mentioned, it's universal, that you should not assume anything. So I think never rely on any such base case or model or any such kind of inference from any other event. Always take the proposition in its letter and spirit. I can see a question here: should the statement of fact be unbiased? Absolutely. The statement of facts has to be unbiased. It has to give a true picture, because ultimately you are a lawyer and you are an officer of the court, and you need to assess the bench the way it is, right? Therefore, the endeavor can be twofold. One, you should first of all try your best to bring out your own case. Secondly, also inform the bench that having said so, please understand that this is the disputed fact and that is raised by the opponent counsel, and hence we entered into a dispute. That was the cause of action, and hence it became the root cause of action for us to enter into the judicial proceedings, or rather invoke the proceedings, right? So that is how you need to keep an unbiased way. You tell your set of facts and then explain and clarify that your set of facts is not supreme, or your set of facts is not gospel, but you clarify that these are the statement of facts raised by the opposition, and you are going to counter them by way of arguments, right? So
So,
yes.
there is also a question from Riddhi Jindal, that how to differentiate between disputed and undisputed facts.
Okay, I think, see, it's very easy. It has to be on a very prima facie basis, on a literal interpretation. Okay, something that is agreed by both the parties. If you sense that by reading a proposition, that goes as an undisputed fact. Something like the population of the country is 5 million. No need to dispute that, right? Therefore, it qualifies as an undisputed fact. Maybe there will be a situation where both the parties have agreed to a set of facts. Those all will be qualifying as undisputed facts. But there will be situations where everything will be challenged, everything will be asserted. The moment there is an assertion, that's a disputed fact, right? That is how you differentiate between an undisputed fact and disputed fact. So the element that you need to find in for a disputed fact is assertion versus acceptance or acceding or admissions. So those will be undisputed facts. So these are basic ways in how you can actually differentiate that. Now, if there are no more questions until now, let's proceed.
Yes, sir. There are
Yeah,
no more questions.
correct. So the next thing that we are looking at is the legal research. Now, please understand legal research entails three key aspects. One is doing a backdrop research of the law, as we just discussed. You have to read the backdrop of the law. You need to start from the very preamble, very statement of objects and reasons, and understand the law. Go for a commentary reading first before going into online research, because commentaries will help you give the overall perspective of how the law has evolved since its inception. For example, if a law was enacted in 1960, you need to find out well as to how exactly the law has evolved throughout until 2010 or 12, for example. Or if you are today in 2020, the commentary may not give you the whole update until 2020. Maybe it was published in 2008. So at least what you will get from the commentary is the law and the judicial interpretation by different courts until 2008. That will help you in two ways. One, you will be updated about the whole law. If someone is trying to make a counter argument, you will negate that using a case law saying that no, this was clearly dismissed in maybe a 1975 judgment, right? That is one benefit. Second benefit is, you will yourself understand the whole law and how it has changed. Maybe the law was A, but maybe now the law is B because of interpretation. So that change in interpretation and the knowledge thereof is very, very important, because if you are not reading that judgment, maybe you are now interpreting in terms of A, which has been overruled, or which has been simultaneously done away with by way of interpreting it as B. Therefore, understanding the law as it stands today is very important. Therefore, for that, you also need to understand the history of the law. So, therefore, commentary should be the first thing that you should look at whenever you research. For those who are not understanding what commentary is, it's nothing but a book which will clearly envisage all the details of a particular provision, and it's ideally a textbook for a particular legal subject, right? Second thing that you need to look at is then the online research. So it's like equipping yourself with more and more research is, and the purpose is being fulfilled by online research. So maybe until 2008 you were aware about everything by way of reading that commentary, but you need to be also updated what happened between 2008 to 2020. That stage will be covered by your online research. Make sure you have at least one landmark judgment, then followed by two more judgments which are supportive in nature, followed by one extremely latest judgment on the issue. And that has to be done for each and every issue. That should be your endeavor in your research. Don't be happy by getting just one great judgment on an issue. I will, if I'm a judge, I'll say that no, sorry, I'm not going to accept that judgment. Do you have any other judgment to prove? Then you'll be clueless, right? So don't be in that situation. Always have at least five judgments, okay, in the manner in which I explained for each proposition. Okay, you may have 20 propositions, you need to read 100 judgments for a moot. That is how it takes. Secondly, there's no shortcut for reading a judgment. I'm sure there'll be a question coming forward how to read judgments. I'll clarify that even before a question is coming in that regard. There's no shortcut. You have to read the judgment in and out. Even if it's the right to privacy judgment of the 9-judge bench in the Aadhaar matter, you need to have clarity that, okay, you need to read the 1025 pages line by line in and out. There's no short cut in that situation, right? So that's what it takes to undertake legal research in a twofold manner. Now, the third step, which I don't think many follow or many even are aware of, is the benefit of doing some ancillary research. Now, please understand ancillary research is something what I mean by saying that, there are things that you should do beyond the law. You should at times understand medical jurisprudence. As I explained, that 50 milliliter example, I would not have understood that had I not read some medical jurisprudence. Similarly, if you are doing an environmental law moot, there will be scientific task forces reports, there'll be a lot of technical reports and validation committee reports. You can use all of that and argue that it's at least has persuasive value, if not binding, and therefore you can always give a sense to the court that you have done some extra piece of research more than what the law states, right? Because the law ideally refers back to committees, etc., and the basis of certain policy decisions are also commentaries and committees and policy decisions, right? Therefore, you need to look at all these, technical validation reports, etc. Similarly, Law Commission of India reports can also help you to a great extent, right? If you're doing a domestic law moot, I think Law Commission of India has some numerous suggestions. In multiple cases, the Supreme Court has dealt with these Law Commission of India reports and have adopted certain submissions. Therefore, the best way to take it up is you always cite a judgment where the document you want to rely on has been used in the past instance, and then say that therefore the credibility of the document cannot be challenged. So even if you're reading any other page, any other para of that document, the credibility of the document has already been acknowledged by the Supreme Court in the past judgment. All you are doing is you are reading a new paragraph, considering the facts of your case, and that is how you are justifying the use of such a document before a Supreme Court or a High Court, right? So that is the approach towards a legal research. Just to summarize it in a bit, the first thing is go for a commentary reading. Second is go for a proper holistic study of your online research. And third is some ancillary research, getting onto the point more than what the law says. Yes, I think there's a question. There was
Yes,
someone
sir.
who, yeah.
Yes, sir. There is question from Himanshu Goyal that should we first start with trying to establish direct establishment of laws, or shall we start with researching on similar cases?
See, I think first of all, the whole thing is you need to have research and then you need to proceed towards your arguments. Therefore, making logical submissions will make sense, but unless you have the research to back it up, I don't see any argument to stand before the court. Therefore, the idea is always look for similar cases, almost identical if possible, and then find out the relevant paras and keep them or preparing them in a separate sheet of note, keep them all prepared in a case note, right? Which can be ultimately helped and built in into your memorial. So that should be the ideal approach instead of first going into the arguments. I think first complete your research and only then discuss or even think about going into your arguments, right? Yeah.
Sir, I have a question.
Yes.
Yeah, sir, we cite like number of cases with 50, 60 case laws in our memorial. So do you suggest to keep the facts of all these cases handy for when you go and represent for the competition?
Absolutely. Absolutely. Whatever judgments you are reading, whatever judgments you are citing, please first of all make sure you are not citing a judgment or you are not even making a footnote unless you have read the judgment. Second, the best approach for this is if you have say 250 judgments in your footnotes, what you need to ensure is you need to have someone in the team, at least a researcher or you yourself, or maybe you can divide that within all three. That if you have like 2-3 months to prepare, make sure you at least read three judgments on a daily basis. And 90 into 3, you will easily cover 270 judgments in 90 days. That is how you need to cover, and you need to prepare a case map. That case map need not have elaborative facts, but at least you should read the judgments in entirety and then make bullet points of each of those judgments so far as the facts are concerned. So that what happens is if you are over the time reading those judgments again and again from that case map, and you have the pointers with you, if and because as a judge have a habit, for example, of asking that, okay counsel, please tell me that you have referred a case in footnote number 79, please tell me the facts of this case. I have often seen that students were clueless about even the name of that judgment I was referring to. The fact is they have simply copy pasted things from some book or textbook or commentaries. They have not even bothered to read that judgment. They have not even bothered to see whether that judgment covers the issue that they are trying to argue or not. Therefore, they get stuck over there. And if you can always answer me in 2 lines as to what were the facts of the case, I'll be happy. I'll think that you are very confident and ask you to please proceed instead of wasting further time in explaining me the whole facts. But that does not mean you should not be aware of the whole facts at all. So the approach is you read the judgment, then you make bullet points, keep that bullet points handy, and then use it appropriately as and when required during the rounds. So that is how you need to proceed. Sometimes there were situations where we were reading about 400, 500 judgments for a moot. And I know it seems huge, but honestly saying, if you read 2 judgments a day, it's not huge, right? So therefore, that is how you need to bifurcate your whole process of reading judgments. And that is how ideally it can be done. If you have more people in the team, nothing like it. They can always help you in summarizing those judgments and reading those judgments and brief the speakers. I think that's the job of a researcher, or maybe additional researchers in some bigger moots, like maybe Bar Council of India or maybe International Law Moot Courts. So that is how one can proceed about making a holistic use of whatever has been read. But make sure whatever is mentioned in the memorial, you are completely reading it in and out, right? There is no gainsaying about that. It has to be read in entirety. Yeah.
So there is a question from Pargat Singh that how to convince judges to consider foreign judgments as court may consider FJs.
As court may consider?
FJs.
Foreign judgments, that is, sir.
Okay, foreign judgments. See, the thing is, foreign judgments ideally do have persuasive value to some extent, obviously not binding. There will be Supreme Court judgments which will clearly say, for example, I think the PUCL versus Union of India, as well as the Kesavan and the Bharati also goes into some bit of it in para 145 or 174 for that matter, where they discuss that how the international judgments and the case laws, unless contradicting to your domestic law, can be used so far as the argument's purposes and to have persuasive value. Second thing is, you will be often having situations where, not a single precedent is available in the domestic circuit. For example, the international patents matters, okay, which are ideally dealt by Delhi High Court in India, because that's the primary, IP body court, where most of the extraterritorial jurisdiction-based matters lie in, and Delhi High Court deals with a lot of international patent matters, which is intellectual property. Now, please understand, international patents hardly have any precedent in India. In fact, it's the US district courts judgments which have been time and again quoted and cited before the Delhi High Court, and Delhi High Court has always appreciated the judgments because of the fact that if you do a holistic comparison of the patents law, especially international patents, you will realize that most of the law has flown out of the principles developed by the US Federal Circuit Court decisions. Therefore, what I'm trying to say is, you can make an attempt at researching whether the judgment of the kind of judgment of the jurisdiction you are relying on has ever been accepted by the Supreme Court or the High Court in the past. For example, the Supreme Court numerous times has relied on a House of Lords decision. Therefore, if you also want to today rely on a House of Lords decision, then please make sure you first cite a judgment of the Supreme Court where in the past they have relied on a House of Lords decision. In that light, argue that therefore I'm also relying on a similar judgment, and unless proven contrary to the domestic law, the same may be considered, if not be binding, right? And then take an approach and try and convince the bench to take that argument and cite a case law. That is how you can rely on foreign jurisdiction-based judgments, and that is the whole efficacy of the principle of comity. Okay, and you can rely on all of such principles where you can rely on these kind of judgments and easily draw a parity. More importantly, if you're relying on any convention or citation of international law, there is a duty in terms of Article 51C, read with 253 of the Constitution, where the state is endeavored, or rather has a fundamental duty in order to uphold the international commitments and the legal obligations flowing out of international treaties and conventions. Therefore, if there is any violation, for example, if there is a tiger habitat today and there is a coal mining going on in that tiger habitat, and if you think that that's a violation of Convention on Biological Diversity in 1992, which is nothing but an international legal instrument, you can cite judgments of ICJ, you can cite judgments of other arbitral tribunals which may have dealt into the issues of environmental law. And if you're today before the Supreme Court, you can always argue in the matter of a PIL and relate back to those judgments and use them as persuasive value. I think that is what should be the approach. You can always rely on such judgments, right? Yeah. So, yeah.
So there's another question from Jashandeep Singh, that should we give more value to facts or to law in arguments?
It has to be equal. There is no, it can't be weighed on a scale, but if you want to weigh it on a scale, it has to be 50-50. The facts have to be completely interrelated to the law, and therefore the cases that you are citing immediately has to be related back to the facts, and that is how the balance is made out, right? You can't just keep citing judgments after judgment and without correlating it to the facts of the case. I think I covered that in my initial portion. So going forward, because I think we have limited time left, let's quickly cover the aspects of memorial drafting and the oral advocacies. Now, in the memorial drafting, obviously, to be honest, it will take an entire day to explain what memorial drafting is and how things go. But let me just give you two quick tips about memorial drafting. Number one is, you should have an approach of following IRAC. Now, I will slowly repeat this as to what IRAC means, and I'll explain what IRAC is. Now, I stands for issue, R stands for rule, A stands for analysis, and C stands for conclusion. Now, IRAC, therefore, is issue, rule, analysis, and conclusion. And that should be the thorough guiding mantra for drafting your memorial. Make sure everything you want to argue fits into this methodology, right? Therefore, you need to state the issue first, then you need to cite the rule. The case laws will all come under the purview of rule. Then analysis, that is where your facts come. You need to analyze the facts to the rule cited, and finally conclude your submission. So if you have like 5 submissions, and 5 submissions further have say 6 or 7 sub-issues each, in that situation, it has to be followed throughout. IRAC has to be the basis of your memorial, and that is how you need to proceed about your memorial. The next thing about memorials is, please make sure you figure out the correct jurisdiction. Now, please understand that jurisdiction going wrong means your case falls apart. And if the court does not have jurisdiction, you can't even argue before that forum. Therefore, make sure you choose the correct forum. Make sure the forum that you are choosing has the ability to give you the relief that you want, right? That the client wants. Now, for example, if you are going for a consumer forum and if you're approaching the state forum, but claiming a penalty or a compensation maybe of a crore, which 1 crore rupees cannot be given by the state consumer forum, in that case, you are not doing justice to your client. You're also not doing justice to the moot court proposition because that expected you to approach the national forum instead of the state forum. Therefore, jurisdictions going wrong will make your case fall apart, and be very, very critical about understanding whether the preconditions for invoking a jurisdiction is met. And that is how ideally you should go about your whole process, right? The next thing that you should keep in mind about memorials is make sure you have your prayer absolutely short and crisp and to the point. Do not repeat your issues in the prayer. Make sure you ask for what exactly you want. If you're asking for any compensation, any damages, make sure you quantify that. And finally, what you need to ensure that, if you have any, as in prayer as such from the side of respondent or the defendant or the answering party or the counterparty, make sure all that you claim is dismissal, or don't repeat everything, just claim for dismissal, or don't, or simply for upholding of the previous order if you want it to be upheld, right? That is how you should ideally proceed about your memorial. Last thing today is oral advocacy aspects. In oral rounds, please make sure you have a proper speech, and that speech should be all inclusive, including anticipated questions. Now, what I mean by anticipated questions is you think that a question may be asked, make sure you have an answer to that, and also make sure you have a case law to support that. And all of that should be on the left side of the paper in your speech, so that every issue, uh, the main submission that you may want to make before the bench is on the right side of the paper, and the anticipated questions and answers are reflected on the left side of the paper. That helps you that whenever you are preparing for over 2 months, 3 months, you are constantly aware about what are the possible questions, and you are completely at ease when such questions actually come from the judges during the rounds. That is what gives you the confidence. Therefore, have that thing ready. The second thing is, it's very, very important to have your mannerisms right. Now, in mannerisms, what I mean is you need to be absolutely calm, patient, be thorough in your approach in explaining the things to the judges. And secondly, make sure that you answer each and every question properly. Now, please understand that a judge understands that someone who is prepared for over 3 months or 4 months for the moot will be absolutely great or phenomenal in the flow of the speech. So if a judge simply allows you to go after your speech, they will realize that, okay, you will do great. Therefore, they ask you questions. They try and desettle you. They try and deflect you from your track. The overall purpose of doing that is just to test your patience, just to test the ability to answer questions. Make sure you do not worry about what are left in your speech, but only focus on answering back to the judges then and there. Never tell this to the judge that, your lordship, I'll come back later to that question, I'm covering that in my issue 3. That is not the approach. Answer it the moment it is asked. Answer it in a short way and then say that, okay, I'll be covering that in detail. However, to answer the question of the judge, or however to assist the bench in that query, this is my submission. That is the overall approach that one should ideally make towards the submissions, right? And therefore, please make sure that you follow these practices day in and day out when you do your moot next. The last thing that I want to focus today is on compendiums. Now, please understand, compendiums is nothing but, the whole set of documents or a compilation of legal resources that you'll be relying on thoroughly during your whole speech. And that is exactly what will be the roadmap or the guiding mantra for you to navigate the bench. It's like if you have to go with the bench and cross an ocean, the compendium will help you navigate through that ocean, right? Because please understand that if you have 30 documents or 30 case law or sources of law in your speech, make sure you number them as 1 to 30, okay? And correspondingly, also ensure that you have the same thing in your compendium and flag the cases as, flag them first and then number them as 1 to 30 in the same chronology, in the same sequence. Compendium, therefore, is nothing but a replication of your documents. So far as the case law, The relevant pages can be put in, culled out, and prepared as kind of a spiral bound copy, which is to be given to the bench. What I used to do during my rounds, let me just tell you that, because if it's feasible, then follow that. If it's not, then follow your own practice. What I used to do back as a mooter was, whenever I used to stand and argue before the bench, the first reference, and if I had to rely on any judgment, I used to tell them that your lordship may kindly refer to flag number 3 of the compendium, which deals with a case of A versus B. And I'm quoting para 45 of the judgment. And straight looking at their eyes, I used to tell them the whole case and explain them what was held in that. And in verbatim, not even by paraphrasing it, but in verbatim. The reason why I could do so is, number one, everything was in my speech and I was preparing that speech for over a long period of time. Second, the benefit that it serves is it helps the judge to be with you when you're arguing. It's very important, because if you're arguing something and if the judge questions that argument, okay, that gets validated by way of that document. So if the document is in front of the judge at the time when you're referring to the compendium, nothing like it. It validates your arguments. It helps the judge to gain the trust in yourself. And therefore, it is a plus for everyone in the rounds. The next benefit of having a compendium is, I have seen researchers standing time and again and passing judgments in and out the rounds. That is not a good procedure. Why? Because it, one, disrupts the court proceedings. Second, every time the researcher stands and passes a bench, the judgment, it takes at least 10 seconds of time, right? So imagine 15 times someone standing or 10 times someone standing means almost 100 seconds, more than 1/2 a minute has been, unnecessarily wasted. I would have at least finished one argument in that time. Therefore, I would have never wasted that time. So I think it's all about moving a strategic move towards your next moot. I hope I've given you all the basics. Obviously this was only a 1 hour session, therefore I could not cover everything in detail, but I hope I've just given you like the broader picture of how things work in a moot court. Therefore, just to finally summarize things what I covered, I initially told you how exactly you should first choose the right team. Then we discussed how exactly one should approach towards going for a correct moot and choosing the right moot instead of relying on a very good brand name of a college. What should be focused at is how exactly you should look for your propositions and whether you're comfortable with that area of law. Then we discussed the pre-proposition stage, the initial research. Then we discussed about the proposition stage and how to interpret the facts, how to divide that into segments and segments of disputed versus undisputed facts. We then discuss about the research methodologies or the techniques, where we discuss the 3-step process of commentaries, followed by online research, followed by ancillary research, right? I think ancillary research is something that will make you win a moot, honestly saying, because that is the additional factor in your whole round, right? Maybe that's the X factor for you to win a moot. I've always won moots based on my additional factors itself. So therefore, I'll suggest that do give importance to ancillary research, no more than the law. If you see really good lawyers arguing in the courts of law, even in the Supreme Court, maybe someone like Mr. Harisagre or maybe Dr. Singhvi, you will always see the kind of interplay they make to the law and the other subjects, such as history, such as science, such as other various such aspects, right? Poetry sometimes. And even judges often reflect these and make comparative analysis of these aspects, right? So it's very important to have that analysis. Then we discuss about a bit on memorials and finally the oral advocacy aspects. Make sure you have a compendium because that helps you to be completely engaged with the bench and not let the judge sleep during the rounds. So that's very, very important. So with that, I would like to part my ways unless there is any other question.
So there is a question from Abhishek Bansal that what about the name of cases when there is clubbing of cases?
Correct. That's a very pertinent question. Thanks for that question. So what ideally happens is, first of all, you need to check whether the clubbing was done in terms of legal procedures. For example, if you're in the Supreme Court, clubbing is done in terms of Article 139 of the Constitution, read with the Supreme Court rules of 2013. The conditions for clubbing is it has to have same matters or identical questions of law or similar questions of law and facts. Once that is finalized, once you realize that okay, clubbing was rightly done, the next thing is you need to have a clear clarity in the cover page as to how the namings are done. For example, if the issues are completely identical and there are no overlapping of issues, in that situation, if there are three matters, write simply as A and others versus B and others, where A is the name of the first party which approached the bench, and B is the first counterparty in the first matter, where the court was, or rather the jurisdiction was invoked at the court. So if today, say me, Muskan, and Hina, for example, file three different matters before the Supreme Court, it will be Saunak and others versus Union of India and others. Okay, that's the example. However, if there are completely different areas or different kind of matters, but maybe one or two issues are interlinked and therefore they're clubbed together. Okay, I can give you an example. For example, someone is charged of a criminal conspiracy out of sedition. Okay, and that's a criminal proceeding. Has lost in lower court, has lost in high court, has now approached the Supreme Court. Simultaneously, someone has challenged a constitutional, given a constitutional favor and challenged sedition as a law at the first place and the constitutional validity of sedition, for example. Now, these two operate in two different fields, but ultimately, these are interlinked to one another for the very fact that, ultimately, if there is any answer given to the second issue, the first issue may be impacted, vice versa, right? But obviously, it's a settled law that the day the crime is committed, the law as on that day will be seen for sure. That's an argument that is to be taken. But all I'm trying to say is that these are different operating fields. One is criminal law, one is a constitutional law. However, there is some interlinking between them. Even in these situations, there may be a club. In that situation, that you distinctly write it. Okay, you write it that maybe appeal under 136 of the Constitution, if it's an SLP, and then write second, and then over there write A versus B, and then write that under Article 32 of the Constitution, say some NGO name versus Union of India. So distinguish that if jurisdiction changes, the nature of the matter changes, but if it doesn't, keep it simply as A and others versus B and others. So that is what I wanted to clarify.
So there is another question from R. Abhishek Castro, that in oral advocacy, any order of presentation you suggest?
See, there's no straitjacket formula for oral advocacy. I'll leave that to the students, and I'll leave that to because everyone has a different way of approach. I've seen people who never prepared a speech but argued brilliantly with a simple pointed note, right? Therefore, what I'll simply suggest is make sure you have a proper model. Make sure you follow the general tendency of how mooting works. You give them the impression of what all are you going to cover in the whole speech, and give a roadmap first to the bench so that the bench is aware of what is going to happen, and then start arguing bit by bit. Make sure you follow the mannerisms throughout. Okay, utmost respect has to be given to the bench, and that has to be reflected by way of your language and words also. So make sure you take all those permissions and necessary things. I didn't cover that in detail, but yeah, that's what has to be done.
I think, sir, this is all with the questions.
Okay.
And now I should further proceed towards the formal vote of thanks. I, Muskan, on behalf of Law Internships, extend a hearty gratitude to Mr. Saunak Rajguru, sir, who honored us with this enriching session and took time out of his busy schedule. I must also mention our deep sense of appreciation to all the students who are present here. I hope this is a great learning experience for all. Thank you once again, one and all.
Thank you so much, everyone, for joining this. Thank you, Veena, for having me here. Thank you, Shubham Bhaiya. Thank you, everyone. Thanks, Muskan, for coordinating this in a really great way. And thank you, everyone, for your questions. I think that was really great to interact with all of you. And, it's really great to also see that Law Internships taking these kind of opportunities and making things available to the students, even in these trying times. I think that's a great thing that's happening. And everyone should endeavor in upskilling themselves, because the first question that any recruiter will ask you as to what did you do during the times of COVID-19, you can't simply say that, I just chilled or I just didn't do anything. It's really great that these initiatives are being taken up, and I hope you continue doing the same. And please feel free to reach out to me for any kind of assistance that may be required. If I can help you with anything, I'll be, grateful, and I'll be definitely making all possible efforts to do the same. So thank you so much for having me today. It was really a great pleasure of mine to interact with the students. Thank you, everyone.
Thank you, Saunak.
Thank you.
Thank you, Saunak.
Thank you so much.
See you soon.
Thank you so much, sir.
Thank you. Bye.
Bye.